Are you facing the daunting decision of whether to testify in your own defense at trial? This choice can drastically impact the outcome of your case, and many defendants find themselves torn between taking the stand or staying silent. In this video, we'll dive into the key considerations that can help guide your decision-making process. Whether you're trying to control the narrative, protect yourself from cross-examination, or weigh the risks involved, it's crucial to understand both the pros and cons of testifying. Stay tuned, because the right decision could mean the difference between freedom and a conviction. Understanding the risks, the weight of your words. Testifying in your defense is an opportunity to speak directly to the jury, but it also opens the door to serious risks. Every word you say can be scrutinized, misinterpreted, or used against you in unexpected ways. Even if you are confident in your innocence, the prosecution will find ways to challenge your credibility, whether through inconsistencies in your testimony or your demeanor. The risks of testifying often outweigh the potential benefits, especially if the prosecution is experienced in cross-examining defendants. As a result, it's crucial to thoroughly discuss this decision with your defense attorney, considering the potential damage to your case. The power of silence, the right to remain silent. Choosing not to testify in your own defense is a fundamental right in the criminal justice system. The Fifth Amendment ensures that you cannot be forced to speak and that your silence cannot be used against you. In many cases, staying silent is a strategic decision to avoid exposing yourself to potential manipulation or cross-examination. While the jury may wonder why you remain silent, they are legally instructed not to hold it against you. If your case relies on solid evidence and effective arguments, your silence may work in your favor, especially when the prosecution has weak or insufficient evidence to counteract. The prosecution's cross-examination, a battle of wits. When you testify, you're opening yourself up to the prosecution's cross-examination, which can be one of the most intense aspects of a trial. The prosecution will aim to poke holes in your testimony by challenging your memory, motives, or credibility. Even the smallest contradiction can be used to undermine your credibility. If you're not prepared to handle this scrutiny, it could significantly hurt your case. For this reason, it's essential to evaluate your comfort level with intense questioning and whether you are ready to stay calm and focused under pressure. This is a major consideration in your decision to take the stand. Emotional impact, how your testimony could affect jurors. Your testimony can significantly influence how jurors perceive you. If you present yourself confidently and tell your side of the story in a relatable manner, it can humanize you in their eyes, which may generate sympathy. However, if you're not able to present yourself well or become overly emotional, it can have the opposite effect, making you appear unreliable or evasive. Jurors often make subconscious judgments based on body language and tone, not just the content of your words. Understanding how your emotional state might impact their perception is vital before deciding whether to testify in your own defense. The role of your attorney, how they shape the decision. Your defense attorney plays a crucial role in advising you about whether or not to testify. While the decision ultimately rests with you, your attorney's experience and expertise will help guide you toward the best strategy. They will assess the strength of your case, the potential risks of cross-examination, and whether testifying would add value to your defense. In some cases, attorneys may suggest staying silent if the evidence is strong and you don't need to provide additional testimony. Their professional insight into courtroom dynamics is an invaluable resource when making this critical decision. The jury's perception, testifying as a double-edged sword. Testifying in your defense can be a double-edged sword. On one hand, it offers you a chance to directly communicate your side of the story, which could help sway the jury in your favor. On the other hand, jurors may see your testimony as an attempt to manipulate their emotions or, worse, an admission of guilt. The perception of your testimony is often as important as the content itself. Your attorney will help you evaluate whether your personal story is compelling enough to outweigh the risks or if staying silent would preserve a more favorable impression with the jury. The strength of your case, when it's better to stay silent. If your defense is built on strong evidence and credible witnesses, taking the stand might not be necessary. When you have a solid case, relying on the testimony of other witnesses and physical evidence may be enough to raise reasonable doubt without you having to expose yourself to cross-examination. In fact, staying silent in this scenario may allow the jury to focus solely on the facts and avoid distractions. A defense that does not require your testimony can help prevent any potential damage that could arise from an unfavorable cross-examination leaving your case intact. When testifying could be beneficial, shaping your narrative. While silence can be a strategic move, there are situations where testifying could be beneficial. If your defense involves complex circumstances, presenting your testimony allows you to control the narrative and clarify any misunderstandings. Your testimony can also help humanize you and address any discrepancies the prosecution might try to exploit. When the prosecution's case relies heavily on circumstantial evidence, providing your side of the story can add necessary context and potentially create doubt in the jurors' minds. Ultimately, testifying gives you the opportunity to present yourself as a credible and reliable witness in your defense. Jury instructions. Understanding the legal framework. One of the most important things to understand before taking the stand is how jury instructions work. Jurors are specifically instructed that they cannot infer guilt from your decision not to testify. This safeguard ensures that the jury does not hold your silence against you. However, if you choose to testify, the jury will be instructed to evaluate your testimony just like any other piece of evidence, factoring in consistency, believability, and credibility. Your attorney will help ensure that the jury understands these instructions clearly, providing you with a fair trial regardless of whether you testify or not. The risk of perjury, the importance of truthfulness. Testifying under oath carries a significant responsibility. You must tell the truth. Failing to do so can lead to charges of perjury, a serious crime with harsh consequences. Even small lies or exaggerations during your testimony can undermine your entire defense and may result in criminal charges. Therefore, if you do choose to testify, it's essential to be completely honest and transparent, no matter how uncomfortable or difficult the truth may be. Your defense attorney will help prepare you for this by discussing potential questions and ensuring you stay within the bounds of the truth during your testimony. Alternatives to testifying. How other evidence can speak for you. Testifying isn't the only way to defend yourself in court. Many criminal cases hinge on physical evidence, expert testimony, and witness accounts rather than the defendant's own words. In some instances, your attorney may decide that these alternative forms of evidence are enough to cast doubt on the prosecution's case. By relying on other forms of evidence, you avoid the risk of cross-examination while still presenting a compelling argument. Exploring all available evidence can often be a safer and more effective strategy than testifying, especially if the prosecution's case is already weak. The final decision, making the call. Ultimately, deciding whether to testify in your own defense is a deeply personal choice, and it's one that requires careful consideration. Your defense attorney will weigh the strengths and weaknesses of your case, your ability to handle cross-examination, and how your testimony might impact the jury's perception. It's crucial to have an open and honest discussion with your attorney about the pros and cons, considering not only the legal aspects, but also your own comfort and confidence. The decision should be made based on what gives you the best chance at a favorable outcome in court. In conclusion, deciding whether to testify in your defense is a complex and high-stakes decision that requires careful thought and preparation. By weighing the risks, understanding the potential benefits, and consulting closely with your attorney, you can make a choice that best supports your case. If you found this video helpful, don't forget to like, comment, and share. And if you want more valuable tips on criminal defense, make sure to subscribe to Criminal Defense Attorney Tips. We'll continue providing expert insights to help you navigate the legal system with confidence. Thanks for watching, and we'll see you in the next video.